Great to see you all here for our Saturday session, which I have to say, want to thank all of you for being here, and I also want to thank our speakers and the ACS staff who helped put the programming together, because I certainly think this has got to be the best convention we've ever had. So. I'm really excited to introduce this next panel because I think this is a topic that really symbolizes, I think, why we should all be in the law, the importance of the law, about our ethical and moral duty as lawyers. That's serving justice. And the title of this panel really speaks for itself. Standing up for the unpopular, the perils and rewards of representing disfavored clients. So at this time, I'd like our wonderful panelists, mid-chew, to come up and take your seats on stage. I'm really, really thrilled to have with us today such a wonderful special guest to moderate our panel. I'm sure you all know Ari Melber, who is MSNBC's chief legal correspondent and a co-host of the afternoon MSNBC talk show, The Cycle. He's also one of us. He's a civil rights attorney and a progressive. And I had the real special pleasure of working with Ari in Senator Maria Cantwell's office. And I can only tell you that I have a great deal of pride in the fact that I hired Ari for his first job in DC. And I can't take any credit for what he's gone on to do, but I'm very, very proud to be associated with him and really grateful that he is here with us today. He's also been very kind to allow me to come on his show a couple of times and even let me talk about my book. So that was very generous and much appreciated. So we're honored to have him here, and it is my pleasure to introduce to you good friend, colleague, and network star, Ari Melber.
Thank you for that wonderful introduction. It's really kind and obviously mutual, because I learned a lot from Caroline and both of our bosses, Senator Cantwell, back in those days, and I'm thrilled with what you're doing here with ACS and what looks to have been so far a wonderful convention with a lot of great people, and that is the case with our panel here. As lawyers, in general, you can take great pride in both what you do, the way you do it, and who you do it for, if you have clients and causes that you believe in. The focus of our conversation is the flip side of that, or a wrinkle, as our esteemed lawyers here will explain, that there are times where the cause you might be proud of does not mean, of course, that you are endorsing or co-signing everything that your client has done or allegedly done, or in the case of a lot of free speech cases, is doing and continues to do. You may find their views objectionable and still want to defend their right to hold them and share them. What we want to focus on is, in particular, the consequences, because it is one thing to say in an academic setting or in theory, well, you go out and do it, and everyone understands, at least within our system, that that is what good lawyers can do, regardless of their personal beliefs, but quite another to consider what the real consequences are in your life, in court, and beyond court, in your career and your livelihood. And I think some of our panelists are going to be able to speak to the climate we're in, not to say that it is the worst in American history, but I think it's fair to say it's certainly not the best. This is not an area where we're seeing unmitigated progress for the basic principle that has been around for a long time. We are seeing challenges to it as well. So with that in mind, I want to turn to our panelists, doing very brief introductions that obviously aren't going to cover their entire careers, but Pardis Kabrai is a senior staff attorney at the Center for Constitutional Rights, working on a whole range of post-9/11 cases, including targeted killing and unjust detention at Guantanamo. Bert Newborn, currently professor of civil liberties at NYU School of Law. Also, many will recognize as founding legal director for the Brennan Center for Justice, and an accomplished litigator and Supreme Court litigator at that throughout his career. And Debo Adegbile, currently a partner at WilmerHale, with a history as counsel on the Senate Judiciary Committee, and work for the NAACP Legal Defense Fund, and in particular, as he'll explain, one especially controversial case, or in the language of this panel, unpopular client, that I think it's fair to say, in the views of some, meant that he shouldn't be allowed to do public service. I say that not histrionically, but literally. And what does that mean in a system if we want to be serious about actually defending the right to counsel? So with that, Bert is going to start us off talking about, to some degree, the personal side of this and some of his own views and tensions, as well as anything else you want to say to kick us off.
Sure. Well, for one, I'm delighted to be here, and I congratulate ACS. I can speak from personal experience this year. Every law school campus that I've visited has had a vibrant ACS chapter that often welcomed me with terrific events. So you guys are doing something right, and keep it up. Now, I've made a career out of representing unpopular clients. I was National Legal Director of the ACLU for a number of years. And so for me, the idea of representing unpopular clients is not a particularly controversial one. Indeed, the world that I've lived in hasn't punished me for it. They've actually rewarded me for representing unpopular clients. So rather than speak about the consequences, because for me the consequences have actually been positive, I want to just say a few words about how to do it well, because it's not easy. When you have an unpopular client that you're dealing with, it seems to me that you want to be careful about maintaining what I call space between yourselves and the unpopular client. Not necessarily because it'll do you any good personally, but because that kind of space, I think, is crucial to the effective performance of your role as representing the client. The last thing you want to do is be viewed by the court, the public, and maybe even by yourself as just a cheerleader, a kind of extension of the client, whether or not you believe in the client's cause. So that I've tried to maintain space in 3 different contexts. I've tried to maintain space in the courtroom, distinguishing myself as a lawyer engaged in what is a systemic responsibility and a privilege of an American lawyer to be able to represent unpopular causes in court, because systemically we need to do so, and not just as an appendage of my client. And maintaining that space is an important factor, I think, in inducing the judge to see the systemic nature of what you're doing and to rise above the judge's own personal views about the case. And I'll tell a quick story about it in a moment. But the other 2 places that you want to maintain space, I think, is you want to maintain, or at least I try, to maintain a public space. I don't want the public to see the lawyer as necessarily just an extension of the client. I want the public to recognize the same thing that a judge should recognize, and that we're dealing here with systemic responsibility and not with a kind of decision to join a political movement and be part of the political movement as a lawyer in court. And then finally, and this is particularly important for someone like me who has rarely represented a client that I would ever have to dinner. Rarely represented a client that I would ever want to really get to know. And that's that you maintain a personal space, a distance between yourself and your client that is often very hard to do. And just a quick story. I see David Brodsky is in the audience, and David and I go back a long way. One of the unpopular clients that I represented when I was a young lawyer, and David was a young lawyer, was Morton Sobel. When Morton Sobel was released, as you know, he was the 3rd conspirator in the Rosenberg atomic spy case. The Rosenbergs were executed. Sobel got 30 years. When he was released after serving 19 years for time off for good behavior, the Parole Board and the Federal Bureau of Prisons wouldn't give him permission to leave the Southern District of New York to go give speeches. He was invited to give a speech at the American Communist Party convention in Kansas City, and they wouldn't give him permission to do it. So I took the case as a young ACLU lawyer. Give you some sense of his unpopularity. The first argument was before a judge named Sylvester Ryan in the Eastern District of New York. And at the beginning of the case, Ryan said to me, Sobel, is that the Morton Sobel from the Atom Spy case? I said, yes, sir. He said, well, he's lucky he's not dead. Get out of my courtroom. So I didn't do very well there, but the case eventually came back before Judge Marvin Frankel, and he had a pretrial conference. And this is the maintaining space, and it's a funny story that David will remember. We troop in for the pretrial conference, and in those years, to maintain the space, this is in the 60s and early 70s, I had a crew cut, I wore unbelievably conservative clothes, I had one tie, and white shirts. And I tried as much as I could to look like a Wall Street banker. And so I came into the court, and Judge Frankel turns to me and he says, you're Mr. Newborn? I said, yes, sir. He said, well, Mr. Newborn, tell me what the government's position is. And I said, well, Your Honor, I don't know. He said, how dare you come here and not know your client's position? And I said, no, Judge. I represent Morton Sobel. That beautifully well-dressed guy over there represents the United States government. And from that point on, I realized that Frankel had accepted me into the club. And I was able to make arguments on Sobel's behalf that were, I think, much more effective. Now, the flip side of that is maintaining personal space. I think the hardest person I ever represented in terms of having to get close to him and spend time with him was Meir Kahane, who, as many of you know, was a radical Jewish racist that formed a racist party in Israel and was a very, very troubling and difficult man. Now, as soon as he entered the Israeli parliament, the United States tried to strip him of his citizenship. And so I represented Kahane in the denaturalization proceedings and in a lawsuit in the Eastern District of New York. Now, if I tell you that I couldn't spend 2 minutes in the same room with him without having my skin crawl, it is a truthful description of how I felt with him. And yet, you owe him everything you can to try to save his citizenship, and it was successful, and we saved it. And the big problem was, Kahane then said to me, look, I know, given the world you guys live in, that you have to pretend that you don't like me. But I know, because of how hard you worked on this case, how deeply committed you are to my causes. And so until Kahane fell prey to an assassin's bullet, he eventually reaped the harvest that he sowed. He was killed by an assassin. Until that assassination, I would get calls from him from all over the world late at night saying, well, I have this problem, I have that problem, what do you think? And every time I hung up on him, he thought it was because I was trying to impress somebody else. So if you guys know how to wear a sign that keeps the personal space, I would be glad to know it.
Sure. Hi, everyone. It's really a privilege to be on the stage with this panel. I thought that I would focus on my experience representing men detained at Guantanamo. I'm part of an organization that started that litigation in 2002 in the aftermath of 9/11. And I think this issue of space is really interesting. And I want to focus not on the space in the courtroom or really what we did in the litigation, but what we tried to do in the public space. And the reason why that public space was so important for us is because, to begin with, access to a court was not a given for our clients. It's often not in the national security context. So the jurisdiction of the court itself was at issue. We weren't sure we could defend them in court. Ultimately, when we got in court, that process did not result in meaningful relief for our clients. So we had to engage with the public and in the political process. All of us, there are hundreds of lawyers. The Guantanamo bar grew to over 600 lawyers at a certain point, and there were all of us from lefty lawyers at CCR like me to tax lawyers who took on these cases pro bono. We all had to kind of learn that work. So that's just a point about the importance and the necessity sometimes of stepping outside the traditional bounds of lawyering and really trying to get creative. But in that public space, our goal has actually been to bridge the distance. Bridge it because literally and sort of figuratively, and that's because it's been in that space that fear and sort of the dehumanization of our clients has been allowed to take hold, and that's, we think, led to a certain public sanction of the denial of their rights and their treatment. That's been very, very difficult, as you can imagine. To give you a sense of what we're up against now in the year 2015, and this is at a time when nearly half of those who remain at Guantanamo have been determined by the government to be eligible for release, have been said to be not serious security threats, at a time when there is extensive documentation about the abuse they've suffered in U.S. custody. At a recent Senate hearing on Guantanamo, a member of Congress said something to the effect of, it's fine with me if every last one of them rots in hell, and if they don't rot in hell, they can rot in Guantanamo Bay. And he was thanked for his passion by other members of Congress. So that's sort of where we are now, 13 years later. It's always hard to sort of close that gap and sort of bring the public up close to the human being and to their plight. I think in this context it's been additionally difficult because of a few other unique barriers we faced in this context. One is that all of our clients were foreign. They were foreign in every way: citizenship, language, culture. They were even more out of sight than most prisoners are. They were in Cuba. There's literally no access to them other than by attorneys. Classification rules, secrecy rules on our ability to speak, to really fully tell their stories and respond fully to the government's accusations was an additional barrier and continues to this day. And then really importantly, there is never a moment when the US public can interact with anyone who has been through this experience. So it's interesting because there have been hundreds of people who've been released from Guantanamo over the years. Today, last night, there's a transfer of people to Oman. A few weeks ago, Omar Khadr, youngest detainee ever held at Guantanamo. He was 15 when he was taken into custody. He was accused of horrific crimes, convicted, tried by a military commission, pled guilty. More complicated. His story and his military commission's proceeding is more complicated than that. But the point is that he is now in Canada. He's been released on bail. He's living with his attorney and his attorney's wife in their home. And his attorney said, "I am glad that finally now the Canadian public can see who this person is." And there's just never that moment for anyone in the American public because no one is coming here, certainly not for release and not even for trial or detention. So that's been the work now, and it's been really challenging. It wasn't always the case that we were focused on the individual. I think there were things that were very effective about the space that we took early on, but shortcomings to it as well. So way back in 2002 when we filed our first case, it was 6 months after 9/11. We were in New York. We were filing in Washington, D.C. We didn't know anything about our clients. We'd never met them because there was no access to them. So we weren't trying to talk about the individual at that time. Our legal director, Bill Goodman at the time of CCR, said, this case, my job is to defend the Constitution against its enemies, and right now its biggest enemies are the Justice Department and the White House. And that was sort of the message. In 2004, when we were up in the Supreme Court in the Rasool versus Bush case, even then, and at that point, a number of detainees had been released. We did know more about who they were and their torture. But there was still a deliberate decision to sort of back up and emphasize principle and not the people. The public face of the case was the attorney we asked to argue it. It was the former Chief Justice of the Third Circuit, John Gibbons. There was a New York Times profile of him shortly before the argument. He was described as a reserved man who was prone to crisp white shirts and pinstripe suits, whose politics veered to the conservative. He said to the reporter, this case is all about the rule of law, and that was really the message. And that's not to say that message was effective. It led to a certain pressure in bringing on board hundreds of other attorneys, and it was truly the motivation for many people who got involved. But we did need to eventually turn to talking about the people we were holding. Even when we started engaging with those stories, I think we fell back on the easier cases, sort of cases of innocence, and there were many of those cases. So wrong place, wrong time, that message was ours. I think what's been harder and where we are now is talking about people who are guilty of some conduct, though not what the government has alleged, where there are actually for them no longer shocking details of abuse, just the ordinary pain of continuing imprisonment. It's those people where our work has been to actually try to bring the people, the public, up close and to convey the experience of their deprivation. And I think of a particular client. His name is Ghalib al-Bahani. I'm working on his case right now. He's been in prison for 13 years without charge. He's now 35. The government's claim against him is that he joined a group affiliated with the Taliban in Afghanistan in 2001. He says, yes, I did, but I went before 9/11. I wasn't there to fight the United States, and I was a cook for this group. We went to court. The court said that serving as a cook for that group, which no longer exists, was sufficient to sanction his continuing detention. And our work now is really to try to bring all of us sort of up close to his experience and explain what it is like to have been at Guantanamo for that long, and to really raise questions about whether we think that kind of punishment is just and acceptable to us. So that's sort of where we are with trying to bridge the space at this point with that work.
And I think we want to build on that and talk a little bit more about how the rules are applied in the context of folks who are alleged or in fact enemies of the state. But I want to get to Dabo before we go into that. And I want to ask, without embarrassing you, by a show of hands, just for context, how many folks here remember Dabo's period as a potential appointee, the confirmation process? So half the room, which helps us a little bit in setting it up. For those who aren't as familiar, in brief, talk to us about whether when you originally took the case here, which you can tell us about, were you thinking or concerned that this could affect your career and future in any way? And then what you learned through this process. And Bert Newborn, you just need to raise your mic up or maybe center it. This is, yeah, okay. All right. Dabo, go ahead.
So I was a lawyer at the Legal Defense Fund, the NAACP Legal Defense Fund, for many years. And in that capacity, I represented a range of clients in many important civil rights cases. They were the controversial cases of the day in the areas of criminal justice, voting rights, education, economic justice. And at the time that LDF made the decision to take on a particular death penalty representation, I was the litigation director. And that case is the case of Mumia Abu Jamal, who had been sentenced to death in Philadelphia for killing a police officer in the early 80s or so. I think I was about 14 or so at the time that the crime occurred. And LDF, under the leadership of the great late John Payton, determined that there were very substantial constitutional issues in play in the way that the jury had been charged in the sentencing phase of the case. And so LDF took up an appeal and joined the case as counsel to Mr. Abu Jamal for purposes of filing briefs in the United States Supreme Court and defending a ruling of the Third Circuit Court of Appeals that had thrown out the death sentence based on a constitutional violation in the way in which the jury was charged in the sentencing phase. And so LDF takes on this representation. I'm the litigation director, and my role as litigation director is to look over the briefs, make sure they cover the law well, that we vigorously defended our clients. And I read the brief. It did all those things. I may or may not have put a pen mark or two on it, and off it went to be filed. And the Supreme Court did not grant certiorari. So the Supreme Court essentially left the lower court ruling, throwing out the unconstitutional death sentence intact. And the result was that our client, Mr. Abu Jamal, was resentenced to life without parole in a correctional facility in Pennsylvania. Down the road, I came to be the nominee to serve as Assistant Attorney General in the Department of Justice for the Civil Rights Division. And in the context of that nomination, many people were concerned that I had participated in successfully vindicating the principles of the Constitution in the representation of Mr. Abu Jamal. And so the dialogue became narrowing the space between the lawyer as lawyer and the acts of the client. And an equivalency was drawn between the act for which my client had been convicted of killing a police officer in Philadelphia and my worldview. And the argument was advanced that I was unfit to serve and vindicate the civil rights laws of the United States of America because I had stepped forward with many able colleagues to vindicate the principles of the Constitution in that case. And frankly, I was a little bit surprised that this was the particular angle that was taken. This may come as a surprise to you, but I've lost some cases along the way, and some of them were controversial, and I think some of them may have pushed the envelope of legal theory. This was a case that multiple federal courts had ruled favorably for our client in a case where no court is drawing any easy inferences on your client's behalf. That is to say, if many of you have been involved in capital representation, the substantive rules, the procedural rules make it very difficult to have a sentence disturbed in that context. And so the fact that so many federal courts had ruled in our way, I thought settled the question.
Which, I'll interject to say, goes to an analysis of substantive legal outcomes. How controversial, quote unquote, can this be when it is actually the law of the land? That is to say, you won. But in fact, the retribution or consequence that's so relevant to our discussion here of the panel is that that wasn't the standard applied, right? To the extent that you want to call what is the current confirmation process and the politics of it a standard, the only interest there that was being pursued was, quote unquote, defending a cop killer. The client himself was the total four corners of the focus, not the substantive parts that you reference, right?
I think to agree that's true, Ari, but I also think that there was an equivalency that was drawn such that many of the stories were sort of identifying me with the conduct for which my client was convicted. And so I think in the public fora, there was a narrowing of that space. And what's interesting, and I think very important for this group to think about, is that it's very easy to make those arguments in the public. That is to say, when you are representing unpopular clients, they're unpopular for a reason. In many ways, our Constitution is designed to provide protections in just those situations, when the force of law or the force of the majority is going to be aligned against people. We have a range of substantive rights, of amendments to the Constitution that are designed to protect those who would be facing the great weight of the government or a mob in other contexts. And what was so fascinating is that the attacks were not only from the public, but from people who themselves have taken an oath to uphold the Constitution, either because they have been elected and sworn an oath to uphold the laws of the United States, or because they are law enforcement officers who take an oath to enforce the Constitution as well. And so the underlying facts in the case obviously are dramatic. They're very difficult. They're in every death penalty case. There are victims. There is heartache. There is no such thing as an easy capital representation. But the fact that this space between what a lawyer does and is supposed to do, really without regard to whether or not you win, but just what must be done in our system, in our democracy, when the great weight of the government is being brought down on the force of in the face of an individual, That is a definitional aspect of a democracy and something that I think we like to think separates us from many other systems. And that was not a principle that ultimately got vindicated in that context. And so it poses a question that some may ask in this room and some have asked in other contexts and at other law schools, which is, if this is the outcome, if this is the result that somebody faces for engaging in one of these representations, like the representations that my panelists have participated in, is that something that young lawyers should opt out of because it amounts to closing a door on your future? And my strong answer to that question is that that's an important question to ask, and it's important for a couple of reasons. First, it's important to ask because these cases, which are in the Klieg lights, are not for the faint of heart. You need to make a threshold determination whether this is the type of case that you're prepared to enter into, because you have to vigorously defend your client, whomever they may be. And if the noise, and if the pressure, and if the Klieg lights, the news, become too much for you, then maybe there's a legitimate decision you should make not to participate in it and to leave it for somebody else. But the larger question is that our system can't survive if there are not people that will step into the breach in those cases. And I would say to the students out here, it's very hard to predict what your future holds. Some of you may be nominated to be on the Supreme Court of the United States, but it's hard to sit here in this room and know that that's going to happen. But the thing that you will know and that you can control is what you do every day when you go to work and the principles for which you stand. And if you step forward to do the things you care about, and if those things include representation in tough cases, that is something that nobody can ever take away from you without regard to what the future holds. So I encourage you to make that. And I would just close this statement by saying, make that assessment and decide if these types of cases are for you. And what you care about may be different than what I care about. And so I'm not saying there's a particular thing, but whatever it is, contemplate stepping forward to do it, and then at the end of the day, you'll see where the chips fall. If the nomination comes, terrific, but you'll be able to go home and speak to your family and hold your head high that you have acquitted yourself in the finest traditions of our laws.
My own sense is what happened to you wasn't because you took on a death penalty case. That happened to be the rock in the road that someone was able to pick up and throw at you. One of the unpleasant realities of public service today is that our system has become so politicized, both in terms of the appointment of executive officials and the appointment of judicial officials, is that nominations of extraordinarily qualified people who would have done a magnificent job and who were clearly the kinds of people that we want doing those jobs often get derailed because somebody goes through your life looking for the rock in the road that they can pick up and throw. The story that came out of your hearings, which is a terrible story, is that there is a risk. It's a risk I took on the day that I agreed to go to work for the ACLU. The day I accepted a job at the ACLU in 1967 was the day I said to myself, I will never be nominated for a judgeship. I will never be asked to serve as a significant figure in an executive administration. It's a terrible thing to say, but it's the truth. I mean, if you take a look at who our federal judges are, and take a look at who our Supreme Court justices are, thank God there's Ruth Ginsburg coming from the ACLU and Thurgood Marshall coming from the LDF, but there's nobody else. And
to your point, Justice Ginsburg has said she wouldn't be confirmed in today's environment, in her view.
And the chances are, and she's a dear friend and a great inspiration to us all. But it was partly because coming out of the ACLU in those years on a women's rights trajectory was a trajectory that was much stronger than if you'd come out of the ACLU on a death penalty trajectory or on a representation of controversial Communist Party trajectory. There is a price that the society pays and that people pay individually for doing that. Let me say to you, on a personal level, I know this sounds like Polonius, but when I turned 75, I got my Polonius license. It is so true that it is a price worth paying on an individual basis. When you look back on your career and you say to yourself, I did what was right, I did what I should have done, I did what I know the system requires if we're going to keep ourselves a free people. And I participated in that, even though it may have cost me an option. The ability to say that at my time of life is absolutely priceless. I warrant it to each of you in this room. In the long run, standing for the principles you care about is so much more important than thinking about the next job. And it drives me... It just drives me bananas that people think that the only way you can be on the Supreme Court these days is if you never say anything controversial during your entire career, that you've got to keep a low profile. It's a recipe for national disaster. Those are not the people that you want carrying out. I would so much rather have a strong conservative on the court who is a principled person who stood up for it than a closet liberal that hid all the life of doing that. Because you know what? When the winds change, that closet liberal's not going to be there. What you want are strong people.
Avoiding all objectionable comments is the key to a healthy marriage. But it is not the same thing we're looking for in public service, to your point. So, Pardis, given that these are the consequences as they are for some, and the admonition for both of your fellow panelists to move past that, is this something that the bar, that the profession, that the people in this room should actually be trying to change? Or in your view, being in the middle of this, especially when you talk about representing alleged terrorists and such, is it so unlikely to change that it simply isn't a practical priority based on the number of things that you have to do in your line of work?
I mean, I think it can change, and I think just looking back in the experience of the Guantanamo litigation, there were important moments when sort of a bipartisan coalition of people came forward to defend those of us who were being criticized for representing detainees. This was earlier on. One example I'm thinking of, and this is sort of smaller scale than Debo's experience, but in 2010, there were a group of lawyers who had formerly represented detainees who went into the Justice Department. They were hired by the Justice Department, and there were attacks on them, on the Justice Department for having hired those lawyers. They were dubbed the Al-Qaeda 7. You know, members of Congress were demanding to know their names, their identities, who they were. Liz Cheney's group, a group called Keep America Safe, put together an attack ad, and there were sort of shadowy figures and sinister music playing. I mean, the idea was that these weren't lawyers doing their duty, but these were co-conspirators aiding the enemy. And the response to that was a letter that was signed on to by a number of department or government officials under the Bush administration. Mike Mukasey came out with a statement really vigorously defending the hiring of those lawyers and the work they had done for Guantanamo detainees. He said, you know, the risk is that lawyers, as a general matter, will look first before representing clients who need representation and will avoid getting involved in any sort of controversy, in particular lawyers who want a public career, things we're saying. And I think that will carve out a large number of intelligent, capable people, and all you'll get is those who've devoted their careers to avoiding risk, which is not what we want in public service. So I think, you know, having seen those examples of sort of standing up, I think there is education we can do. The other thing I think about, and this is just to the point of empathy and sort of needing to do creative lawyering for really hard cases and hard issues that come up in this context, I think it's also important to educate the public and the bar and all of us about the fact that trying to create empathy for a client outside of the legal system, where that's needed, is also not a signal of agreement with their views or conduct. But that is often part of what's required for zealous advocacy, but that, you know, it doesn't mean sameness with your client. There is still a distance you can have from their views and what they are alleged to have done. But empathizing and trying to create that in the public sphere is just part of the work as well.
In terms of taking questions, we have some note cards that are going around the room, and we highly encourage you to fill them out if you have a question or a comment, because we will take them up here and put them to our panelists. You can identify yourself in the note card if you want. You can make it a comment or an argument, or it can be a straight-up question. But please go ahead and do that, because I will start taking those for the ending of our panel. To your point, Pardis, I mean, lawyers get excited about letters. Oh my God, how many people sign the letter, right? And sometimes they matter and sometimes they don't. I think another big impact in the same area you're talking about, though, earlier during the Bush administration was when there was a Pentagon official who made a public statement saying, you know, we're seeing a lot of American law firms, even top-flight law firms, working with their lawyers, being co-counsel on these habeas petitions at Guantanamo, and companies should really consider whether they want to be in business with them, which, coming from a government official, is a very serious type of admonition from the Pentagon. And there was a deserved outcry over that, and he was dismissed from the Bush administration for that comment on the idea that that was too far, that we shouldn't be boycotting or blacklisting companies because they work with a firm that does this kind of pro bono counsel or unpopular client litigation as we're discussing it. So at the level of your recruitment, can you tell us, have you seen any difference to when and how people want to be involved, or that's not really a driver of it, to the extent you can see whether the climate is supportive?
No, I mean, the Guantanamo bar had grown so large, it's kind of hard to imagine a time when there were very, very few of us. It started out in 2002 with about 13 lawyers. It was CCR attorneys, a group of veteran death penalty lawyers, and then one firm, Sherman & Sterling, sort of was hired by the family of a group of Kuwaiti detainees. After those families had gone around to half a dozen other firms and been turned down, that firm stepped forward. I think there, you know, it takes someone stepping out, and I think Sherman's role early on was critical to our ability to recruit and make it safe for other attorneys, other large firms, other practitioners to come on board. But there was absolutely a growth. From 2002 to 2004, there was really nothing. But in 2004, once we sort of established the right of detainees to go to court and challenge their detention, there were lawyers flocking to CCR and sort of overwhelming us, wanting to get involved. But I think it wasn't just the involvement of people who joined this work expecting to take on unpopular clients like groups like CCR. It was the involvement of unlikely attorneys, Sherman & Sterling and those attorneys early on, that I think that helped promote, you know, make it safe and bring on board many, many others.
So what I want to do is jump back inside the courtroom and talk a little bit more about practice and then start taking in the questions. So for all of you, on the practitioner side, when you deal with folks who are explicitly facing charges of being enemies, not just speech or some sort of objectionable conduct, but folks who are seen as enemies of the state or supporting those kind of foreign threats and enterprises, walk us through, you talked about space, walk us through how you approach that inside the courtroom, whether you have any preference for judge versus jury trials, if that's an option, whether you think in your experience the rules are really applied the same if you're facing, as we see in federal courts in the past couple of months, someone who's alleged to be trying to go give material support to ISIS or help other people get over to Turkey to get to Syria to join ISIS. In your view, in our system, do those folks face the same equal application of the rules as other defendants or not? And if not, how do you try to bring it back to scale for them to get a fair treatment in that context, if anyone wants to talk about that inside the courtroom?
Well, I'll take a quick crack at it. I mean, I know what I would try to do. I don't know if I'd be successful. That's what I meant by distancing. It can sometimes be difficult, but when you have a client that you know the judge is either afraid of or hates, the least effective thing you can do is to behave either publicly or in the courtroom as simply an extension of that person, because the judge is just not going to listen to what you say. If you're starting from a psychological pit that you have to climb out of in order to get a fair hearing for your arguments, it is sometimes necessary, as a matter of good representation, Forget about whether it is good for your reputation, or your future, or your psyche. It's important as a matter of good representation to distance yourself from an unpopular client. Now, some people think that that's a kind of cowardice, that you should dig right in and be part of a movement. I've always thought that that is self-indulgent. I've always thought that when you're in the courtroom with someone that you know is a red flag for the judge, you've got to find some way to deflect the judge's animus. And the way to deflect that animus is to call on the common sense of obligation of the American legal profession on defending the basic rights, even for people that we are troubled about and don't like very much. Well, I've done that sometime in cases that I've had, and I've had the client become annoyed with me, saying, I don't like you talking about me that way. I don't like being positioned that way. I thought you were my lawyer. And I've said to them, look, if you want a lawyer that's going to be your, just an extension of you, maybe I'm not the person. I said, but if you want a lawyer who's going to just go to bat for you in a way that will try to get you maximum success in this courtroom, trust me and let me do it.
And how do you appeal to a jury? Is it partly the jury selection? Is it partly making them feel that there's something larger in play than simply this defendant?
Well, I don't want to hold myself out as an experienced jury lawyer. I've only tried a couple of jury cases in my life. And so I don't...
More than all the law students here.
Yeah, well, it is, to the extent that I've had jury trials in controversial cases, I've had a couple, it is doubly important in that setting, where it's an ordinary member of the public, for the juror to look at you and see the law and not see the client. That the client is there, and of course, you don't run away, you don't betray them in any way, but you don't create an aura of camaraderie, you don't create an aura of we're all part of this together. You build a separate space for yourself. And within that separate space, you do everything possible to advance the legal rights of that individual. And it's a self-conscious, I find it self-conscious, because my tendency, my personal tendency is to befriend my client, to think of my client as someone that I am close to and that I wish to be close to and that I want to be friends with. But I think the lawyer as friend in a case involving extremely unpopular people does not do your client any good. It may be self-indulgent, it may make both of you feel better, but in the long run, I don't think it advances the cause. And so many times, I think, I've been considered cold and unfeeling by my clients, and certainly by my clients' supporters and my clients' family members. But I think it's part of the price of actually doing the best job you can inside the courtroom, especially with a jury.
Ari, I wanted to throw in a different conception of clients and unpopular clients. I think there are those unpopular clients who will be unpopular for all time. Enemies of the state, people accused of killing other people. Through eternity, these folks are going to risk the ire of the populace and have very substantial legal and factual arguments to overcome. There are other clients in our history and in the history of this country who are unpopular in the moment and later, through their bravery and willingness to step forward, do something that is fundamental to teach us what the Constitution or what the conception of equality and liberty means. And that is to say that the marchers, I'm quite sure that the marchers being arrested in Selma were not popular when they showed up in court and when my predecessors at LDF and others stood with them. The students that were desegregating schools and being marched into all-white schools were not particularly popular when they stepped forward. And I'm sure that Clarence Gideon himself was not particularly popular. And the point here is that unpopularity, sometimes it's decided in the moment, but the principle of giving that voice, of giving a voice to the voiceless, and in having as your North Star the Constitution and the commitments we make to each other, gives an opportunity for those brave clients, not just lawyers, but for those brave clients to teach us through their commitment to the Constitution what we should be as a people.
That's such an important observation because, as you point out, there really are at least two categories of unpopular client. A category of the Malaman say unpopular client who's done something that is just horrendous or is alleged to have done something horrendous and is going to elicit both fear and hostility. And then there's the client that is essentially challenging the status quo in some meaningful way. And the status quo doesn't like it. And that turns that person into a very, very unpopular person. And it's important in your own thinking to make a distinction between those two because you may want to have different tactics and different behavior depending upon the nature of the unpopularity. It's also possible for somebody to be both, to both have done something and but the two categories. I'll say that even in the second category, I mean, I've had, I'm thinking of, I used to represent teachers years ago during the Vietnam War who wore black armbands to oppose the war and who were dismissed because of wearing the armbands to class. And they were locally tremendously unpopular. On the other hand, what they were really doing was trying to stand up for something very important. And they were, in the long run, they were viewed as heroic. But I found that even in those cases, my representation of them was more effective if I distanced myself. If the judge saw me as an emanation of the First Amendment and not as an opponent of the Vietnam War. And so that the importance of creating that distance, even in the kinds of cases you point out, is very important, but it would be a terrible mistake to think that all unpopular clients are the same.
I think just to add, in terms of even people who've been accused of horrendous crimes, and I'm not a death penalty lawyer. We'll hear from one in a minute. But I think when it comes to issues of punishment and how we treat people, treat even those people, that's where I think it is incumbent on us as lawyers and advocates to find a way of talking about the human being, again, without agreement with the conduct, the views, but of really trying to show the human being. And I think that's absolutely essential when it comes to issues of what punishment we as a public will find acceptable and what a judge and a jury would find acceptable for that person.
We're going to start with some of the questions from all of you, and we're going to continue to take cards. So if you have a question or thought or hear something you want to speak to, that is a rolling process. Like rolling admissions, but less selective. So there's a very good chance your question will be asked. An interesting one right off the bat that takes us in I think, a different direction than any of the four of us have been discussing, which is why it's great to hear from all of you, is the following question. What about an issue like same-sex marriage, wherein arguing against it is becoming increasingly unpopular? Should firms representing clients opposed to same-sex marriage continue zealously advocating as per their duty, or give in to popular opinion or personal conscience?
So I think Paul Clement famously left a firm that had difficulty with his representation in a related area. And Paul Clement is a very talented litigator. He has a particular worldview, but he's a very able lawyer. And I think that he is a lawyer whose litigation commitment to his clients we can respect. He left his firm because he wanted to provide service to the client that he committed to representing. Now, you don't have to agree with his side or his view, but his commitment that he should be able to advocate his view is pretty clear. I think the danger in having no-fly zones in our legal system is that that wheel goes around, and inevitably, who is to decide what the exception in the right to counsel is? That you should be entitled, and I understand it's different in a civil context, certainly, than a criminal context, but the fundamental point is the same. And who is to say who should not be able to receive representation when there is litigation before our courts, whether it be criminal or civil. It's a different point than agreeing on the substance, but that a client should have their view vindicated by able counsel seems to me something that we should be able to agree upon.
The right to, the obligation to make unpopular arguments is not simply something that the left has. It is an obligation that cuts across the spectrum, and if conservatives want to make unpopular arguments, I think it would be outrageous to punish their lawyers for making them. And so Paul Clement was right, and the firm was weak, and if I were a client, I wouldn't trust them. I'd move to another firm if I saw a firm that lacked the courage to let one of their important litigators make a controversial argument.
This question is more about the pressures outside the courtroom than anything that's formally legalistic. Reading now. What role does race and ethnicity play in the public outcry in opposition to certain unpopular clients? Or is the bigger factor always the specific facts of the case? And this questioner writes, I haven't heard as much outcry about the attorney representing the Aurora movie theater shooter, end quote.
Well, race is real in the United States of America. As somebody famously wrote, race matters. And we turn on the news every day and we see that fact playing out in a variety of contexts. So to be sure, the burdens of our history in the area of race is something that continues in the courts and in the public space. And where you have a case that emanates and has as its locus these issues, that absolutely is something that feeds the public discussion about it. I think it's unmistakable but to acknowledge that that's the case.
Unpopularity is simply a result of fear. It's fear that drives the virulent unpopularity that would make anybody nervous about taking on a claim. And you don't have to be a trained psychologist to know that in this country, race and ethnicity feed fear. And so, of course, issues that involve people that half the population is afraid of to begin with is...
Bert's mic fell off.
Bert's
mic fell off. So you want to put it back on?
It says, you know, this is not going to get me confirmed. It says Bert's mic fell off. And that's not true.
Well, that's it, Bert. While Bert fixes his microphone, I will say Polonius may not know this, but that's the hip-hop spelling of Mike, M-I-C. We take that. We accept that.
Before I was so rudely interrupted by somebody tearing my mic off, of course, race and ethnicity affect the fear that is part of virulent unpopularity.
I've got a couple questions here that I think pick up on practice areas that you discuss, but suggest some people want a little more detail or texture. One question reads, can you talk about a client whom in some way you didn't fully distance yourself from, and how you might have used closeness or similarities between their case and your convictions to humanize them or try to make them less unpopular? So understanding your theory of the case or practice, but a different approach. And another that says, the panelists have talked about maintaining space between lawyers and unpopular clients, but how do you do that in the context of community, social justice, or movement lawyering? And I'll take a moderator's privilege and add to that and say, if you look, are you shaking your hands at the moderator's privilege, Bert? He's
cogitating.
He's just thinking. And I wonder whether there is a fundamental difference between some of what we're talking about where the case exists only on its individual standing and you're trying to protect or defend someone, and cases that obviously have the larger movement or social justice, high-impact litigation context, particularly in an NAACP and to some extent CCR, cases around how people are being treated as protesters in Baltimore or Ferguson, for example, may involve some of the same challenges inside the courtroom, and yet there may be a countervailing pressure on that attorney to try to uphold what is a community that is organizing around the fate of those individuals or the belief, the allegation that their First Amendment rights are being compromised because of their content. Those kind of cases seem to be a tough call, even as the space consideration may be a very real thing to win the case.
Sure. So taking a quick stab at them in order, the first one is a context where you have had to give voice to the underlying cause and circumstance of a client. I represented voters in New Orleans in the post-Katrina voting case, where the first municipal election was about to happen, and people had been dispersed all over the country and the South and the Southwest by virtue of the floodwaters. And the question was, were they going to be able to vote? There was not an election system that contemplated this type of natural disaster. The Voting Rights Act had not been passed with this type of disaster in view, but talking about the centrality of democracy in carving the way forward, as expressed through our individual clients who had faced the floodwaters and lost everything in many contexts, but still wanted to have their voices heard in that courtroom, was an important part of making their case to the judge who himself lived in New Orleans and understood the plight. And so the legal claim was very difficult, but the judge, understanding the underlying value and that it was necessary for these voices to be counted, applied sufficient pressure to the legislature that there were some modifications made to the system to make it a little bit easier for people to vote. It was not a home run as a litigation, but it was very important to express in real and tangible terms that what democracy required in that moment was to allow these people to decide who would lead them out of this circumstance on a local basis. And so that's one example. In the larger issue of dealing with cases where there are movements around the case, look, it's very important. It's part of what drives, mobilizes people. It's part of what will drive the media cycle, regardless of what you're saying in the courtroom. Sometimes what's happening on the street, or if you have a very vocal person, they're going to get the mic. You know, people like you may be less actually you are interested with what goes on in the courtroom, but some of your peers in the media may be more interested in what's going on outside the courthouse because it's better TV than the procedural or technical arguments that are happening inside the courthouse. So you have to be aware.
My peers are only interested in journalism, not ratings.
Is that right? Well,
you didn't know that?
I have to. I need a different cable subscriber. But so the point is that you can't live in a world where you're not cognizant of that. But here I come back to the space point. You have a job as a lawyer, and they have a job as activists. And your job as a lawyer, and this has been real in civil rights litigation since the days of the school cases and the differences and how we should move to desegregate schools. There were people that had views about how it should go, and then the Legal Defense Fund and the many lawyers who cooperated with them had their own legal strategy. And you just have to, it's a negotiation. You won't always make the community happy, but as a lawyer, your duty of loyalty and your obligation is how you steer the litigation for your client. And so you have to be prepared to take that criticism also. Very often you get criticized from two sides, as I think Bert may have alluded to.
Yeah. You know, the question made me think back. Can I think of a case over the years in which I was very closely, affectionately connected with clients, but felt somehow a need to distance them, or should have and didn't. And I think back to the early cases challenging the constitutionality of the Vietnam War. I argued those cases and represented just a number of remarkable people. Maybe the most wonderful, conscientious people I ever met, ranging from Marymount nuns to priests to anti-war activists, and I loved them. I loved them. They were remarkable people. And yet, when I was presenting the arguments in court, I carefully walled myself off from them, to the extent where at the ACLU I organized a double mechanism. One, I spoke in court, I never spoke publicly. My voice was the voice for the judge. I had to persuade them that this was something a judge should pay attention to, and it just wasn't politics by a different name. It was law, and that I was begging him to take that into account. And I encouraged the ACLU to organize them as a way of speaking publicly and to use the case as a political organization mechanism, but not my voice. Not the voice of the lawyer. The voice of the lawyer, I thought, was a precious resource. It turned out my voice wasn't very effective, but I thought it was a resource that would be used and should be used only in court. And it is really hard and to this day, I sort of feel badly that I wasn't as close to some of those people as I would have liked to have been. But I think the responsibility required distancing.
I was just thinking about some of the tensions, again, in the Guantanamo context between the movement of us, and there are many, many organizations and lawyers who have been advocating for Guantanamo's closure for many, many years, and then those of us who represent specific clients and have to really look out for the interests of those individual people. And there is certainly, over the years, a certain tension that's come up. One context is where we have a number of clients who are facing charges in the military commission system. And one of the points taken by the broader movement is that in order to shut down Guantanamo, we need to shut the prison, transfer those people the government intends to charge to the federal court system, and bring charges against those individuals here. That isn't necessarily the best case for some of the people that we represent. We've had to take different positions despite our broader position on closing the prison and being against military commissions, but the particular interests of specific clients have really have forced us in some cases to go a different direction. We've not been as public about it. It's not something we've done in our advocacy, but there's certainly tension that's come up that way. And then it's the issue of space again, and sort of how close we've gotten to our clients. I think we've all sort of used the closeness with our clients as a way of bringing in the public. For me, it has never been a matter of relating my own personal background or situation to a client and sort of talking about that publicly. There is that space I've taken, but in terms of getting close and sort of talking in a very personal way about the individuals we represented and their circumstances, I think we've used that as ourselves as sort of a proxy for the broader public.
While you're speaking, Pardis, there's another question explicitly for you. How has the release of the torture report affected the ability, your ability to defend and present evidence regarding Guantanamo detainees? And does that sort of government classification of mistreatment affect, in your view, people's perception of what's happened to some of these individuals and your representation of them?
I think the torture report is there is a lot of documentation we have about the treatment of people, not just by the CIA, but by the military, and not just at Guantanamo, but in prisons in Iraq and Afghanistan. I think the torture report, though, is the best evidence we've had, the most authoritative evidence we have, documentation we have of what's happened and who has been responsible. And I think for those of us who've been calling for accountability, it is the best tool we have right now to press for that. What's been, I guess, interesting and kind of made those of us who are sort of trying to advocate for accountability in this area is, despite that information, I mean, if you've read any part of the torture report, it's something to sort of see in black and white some of the methods that have been used against people. It is horrific stuff. It is absolutely brutalized human beings, and yet despite that evidence by a Senate committee, by a government body, there's still this debate about whether those methods should have been used. And if you believe the polls, there's a good part of the public that believes that those methods were acceptable. So I think we see things like that, and we wonder, what would it take to move people and to sort of push for accountability. And that's what leads me to think it's still not enough to read that information on paper. there's an extra step that we have to take in terms of making the people who have experienced that sort of real for the public, and that's been our struggle.
Well, this is an aside, but we've seen the power of video in several recent cases here and how much it can galvanize national discussion. And you think back to the CIA illegally destroying all those tapes of interrogations. They knew what they were doing and how different video would be even from the report. One more question here on a practical matter, and then I think any final thoughts you guys want to share. We have a very short question from someone who's on the money in the audience with this discussion about weighing risks, which can be somewhat theoretical if you think about certain cases. This person's saying, fine, but, quote, doesn't student debt force graduates to take safe, low-risk jobs?
Student debt is a very real issue, and
it's also unpopular. So there's some sort of connection here.
That's absolutely right. So obviously people have to think about their own path and how they navigate it, right? And starting with a mortgage on your brain when you set off to become a lawyer, you do have to think about how you're going to pay that down over time. In my own case, I started my career at a firm. I made a little bit of headway on some of my debt, and then I was very fortunate to get an opportunity to work with the Legal Defense Fund while I was at the firm. And then I was invited to come and join the Legal Defense Fund and spent more than a decade litigating civil rights cases there. And so there are many, many things that will be challenges and stones in the potholes in the road in terms of doing things that are important to you, and there will be very dramatic choices that you need to make in your life. But I don't think that there is anybody that has a free pass to not find a way to get to the things that you want to do over time. There is always something you can do in every context, even if you're doing something to pay the bills and commit to lowering your debt. There are lots of places where you can do that and have a pro bono representation or serve on a board or participate in ACS. So I don't think that I think that it's a real issue that the student has identified, but it's not a dichotomous world. You have many goals in life, and you have to be savvy enough to think about how you can address these multiple goals and steer yourself toward that ultimate goal of yours, even if the road winds.
And let me go Pardis and then Bert on final thoughts.
Yeah, no, I would just agree with Jabo there. I think debt is real. I have lived it. But I think it's right that there is a way that you can find whatever your day job may have to be to support yourself, to support your family, to pay off debt. There is a way to stay involved in your free time through other activism you do outside of the realm of what you may need to do in terms of regular employment. I think final thoughts just, again, this point of just emphasizing the need for all of us to understand the scope of what zealous lawyering means, that it means stepping outside of the court, needing to do that, particularly for these kinds of cases and these kinds of clients, needing to think creatively and non-traditionally about our advocacy, needing to create empathy in certain cases, and needing to also be clear that none of those things mean agreement. They mean an understanding of circumstances in a person's situation, but they don't necessarily mean that you sanction or agree with the client's views or conduct.
The one thing I'd say, especially to the students, the one thing you have that I wish I had is time. The truth is, you can't do everything all at once in your life. And so if there's student debt to be paid off, then you focus on getting at least enough of it paid off that you feel comfortable that you can move forward. I spent 3 years as a tax lawyer on Wall Street because when I graduated from law school, I had some financial obligations. It wasn't the kind of debt you guys have now, but there was stuff that I had to deal with. And I spent 3 years working hard in a job that I didn't love, but I didn't hate. And then the time came when I could move. That time will come for you. You don't have to give up on your dreams because you have to defer them a little bit. And there's always good work to be done. My final thought, there probably is no more important value in our whole system than encouraging lawyers to take on unpopular causes. We have a system where power is concentrated so strongly in the hands of a few people with the ability to manipulate the public and manipulate public opinion. And when people challenge that, they're always going to be unpopular. And unless they have committed lawyers who are going to protect them against the inevitable kickback of the powerful, the system just doesn't work. And the real failure and the sadness that I share with you is that there's been a failure, not of the bar. They send letters around all the time, signed by lawyers, talking about how important it is to have to do unpopular things. It's the bench. Judges should be out there defending the responsibility of lawyers to take on unpopular causes. They are the ones who should be the great spokesman for this principle. And years of trying to organize them to do that have simply been a failure. And I just don't understand why. And maybe we should make one more real effort now, that the spokespersons for our ability to do unpopular causes can't just be us. It has to be the judiciary, and the judiciary has failed us in that up until now.
Well, I will say at a conference like this put together by ACS, we see so many different types of inspiring people, inspiring intellect, inspiring expertise, people who work so hard, inspiring credentials, because you look at some of the people we've heard from. I think it is eminently fair to say this panel is inspiring for its courage and for its example. So join me in thanking them, and thank you.